morning, committee and guests. Welcome to our committee meeting today. It's not snowing yet, so we're in good shape. But I want to welcome everyone. And today we'll start off with House Bill 2563 with seed law, and then if we wrap that up soon enough, we want to finish working 2456, the lifetime hunting and fishing license bill. So before I start here, I just want to recognize Jeff Vogel is here. He'll be testifying later on, but he has a special guest. His Emma Vogel, would you please stand up? She's visiting today, and so we'll be seeking your input later on how we how we did. So welcome to the committee, please. So with that, we will begin with the revisor, and Tamara, welcome to the committee.
Thank you, Mr. Chairman, and good morning, committee. House Bill 2563, as amended by the House Committee, would amend several provisions of law, the Commercial Industrial Hemp Act, Kansas Seed Law, and the Pest Act. This is a somewhat lengthy bill, but a number of the changes are related to updates in terminology and practices. So I'm going to go through the more significant changes and just note where there are technical changes. So I'm going to begin with the Commercial Industrial Hemp Act. New Section 1 would allow the Department of Agriculture to provide industrial hemp testing services to persons or governmental entities that are not licensed under the Commercial Industrial Hemp Act, including law enforcement agencies. When the department has the capacity to do so, the secretary would be authorized to establish a fee schedule and rules and regulations for that testing. Any fees collected for that testing would be credited to the Laboratory Testing Services Fee Fund. And additionally, upon request, the results of those tests may be made available to the KBI. So now the rest of the industrial hemp amendments are at the back of the bill, starting with Section 15. The section would expand the definition of state educational institution. Section 16 would remove language concerning the inactive research program and would allow the secretary to establish an advisory board through rules and regulations that would provide input and information regarding the regulations of industrial hemp in Kansas. Additionally, this section would allow the secretary to require individuals employed or seeking employment with the Department of Agriculture who oversee or regulate commercial industrial hemp to submit to fingerprinting and a criminal history record check. And then sections 17 and 18, also relating to commercial industrial hemp, make technical changes. So I'm going to move on to the Kansas Seed Law. And this sort of starts with Section 2. And this would establish labeling and coloring requirements for seeds that have been treated with an irritating or poisonous substance that is harmful to humans or other vertebrate animals. This section would also provide labeling requirements for seeds that have been treated with substances that are not harmful and seeds that have been treated with an inoculant. Sections 3 through 11 would make various additional amendments to the Kansas Seed Law, again, more of a technical nature. Section 3 of the bill would amend the definitions, including the definitions for noxious weed, agricultural seed, and restricted weed seed. It would also add a new definition for the term prohibited weed seed, which would be seeds or bulblets of species that are highly destructive and difficult to control, as designated by the secretary through rules and regulations, in consultation with various industry organizations and programs within the Kansas State University College of Agriculture. Section 4 would amend the labeling requirements for agricultural seed by including requirements for certain hemp seed labels, reorganizing existing provisions, and making technical updates. Section 5 would amend the unlawful actions contained in the Act by reorganizing existing provisions and making technical updates. Section 6 would amend provisions relating to wholesaler and retailer business registrations, including authorizing the secretary to revoke, suspend, modify, or refuse to renew any registration under certain circumstances. Section 7 would amend the penalties for violations of the Kansas Seed Law, including authorizing the secretary to assess a civil fine of not less than $100 and not more than $3,000 per violation. Monies collected from those fines would be credited to the state general fund. And then sections 8 through 11 make technical updates. So now turning to the Pest Act. Sections 12 through 14 would make amendments to the Pest Act that relate to live plant dealers. Live plant dealers are required to be licensed. However, there is currently an exception for those who do not import or export plants into the state or out of the state that have annual gross receipts of less than $10,000. This bill would remove that exemption and replace it with a reduced license fee not to exceed $50 for live plant dealers who do not export live plants out of the state, have annual gross receipts of less than $5,000, and have a single location other than temporary locations. Additionally, any person who conducts business as a special event live plant dealer would not be required to obtain a license, but would be required to register with the secretary. The bill would take effect upon publication in the statute book and pass the House on a vote of 113 to 8, and I'll be happy to answer any questions.
All right, thank you, Tamara, very much. Committee, any questions for the reviser? Senator Dahl.
Thank you, Mr. Chair. What's a live plant dealer?
So a live plant dealer is someone whose business includes growing live plants for sale or distribution, buying or obtaining live plants for reselling or reshipping within Kansas, or planting, transplanting, or moving live plants within the state to plant for others.
You have another question, Senator Dahl? Okay. Any other questions for Tamara? Senator Reichman.
Thank you, Mr. Chair. A lot in this bill. I know a little bit about commercial industrial hemp, but not a lot. And I noticed in your section 15, it says language require fingerprinting and criminal history check for persons licensed under the research program. What would be the reason for that? If you can't, I can ask somebody else.
I would defer to the department to speak on that.
Any other questions for the reviser? Thank you very much, Tamara. Next up, we will have the proponents. We will begin with Jeff Vogel, Program Manager for the Plant Protection Weed Control Program for Department of Agriculture. Welcome to the committee, Jeff.
Good morning, Senator Kirshen and members of the committee. Thank you for this opportunity to provide supporting testimony on House Bill 2563. I serve as the program manager for the Plant Protection and Weed Control Program at the Department of Agriculture. Also in attendance are several members of my staff. Scott Marsh, he's our state weed and seed specialist. Braden Hoke, he's our industrial hemp supervisor. And then on WebEx, Jennifer Smith, she's our area supervisor and Kansas City metro area specialist for our program. The Plant Protection and Weed Control Program has a diverse set of responsibilities and amongst others works to protect the state's natural and cultivated resources from the introduction and outbreak of harmful plant pests. We provide consumer protection to ensure that seed offer for sale meets label guarantees, and we ensure industrial hemp grown meets the requirements of the Commercial Industrial Hemp Act. To conform with modern practices, House Bill 2563 updates 3 of the acts the program administrates, as was discussed earlier. We do want to make sure it's important to note that in the bill, new section 1 is at the beginning that refers to hemp testing. That is updating the Commercial Industrial Hemp Act. We are not adding language about hemp testing into the Seed Act, even though that follows right after that. But within the process of developing this legislation, the department met with many stakeholder groups prior to the session, and those groups are listed in our written testimony. But they include Kansas Grain and Feed, Kansas Agribusiness Retailers Association, Co-op Council, Farm Bureau, Kansas Seed Industries Association, KNLA, which is the Nursery and Landscape Association, the Industrial Hemp Advisory Board, and many, many others. But first, as we get into this, I'd like to cover the changes to the Seed Act by highlighting just a few items and the justifications behind it. Parts of the Seed Act have not been revised in many decades, quite honestly. The bill modernizes the law by revising and extending the labeling of treated seed, providing further protections to those handling treated seed. It adds oil, food plot, and cover crops to the definition of agricultural seed to extend the protections of the seed law to farmers of those types of seed. Currently, the law, the Seed Act, has a list of noxious weed seeds in it that includes some species that are not declared noxious under the Kansas Noxious Weed Act. To clear up this confusion, the bill references the Noxious Weed Act and those weeds listed under that act by reference to reduce the number of times the seed law would be needed to be revised. It's important to note that the term noxious means the same thing in both laws, the Seed Act and the Noxious Weed Act. In addition, the bill creates a prohibited weed seed list to avoid confusion regarding the non-noxious weeds being part of that list. And that would be placed in regulation. We also are moving the restricted weed seed list to regulation in the table form to make it easier to read and understand and streamline the process of both species. There are requirements to species to be listed under both in the bill, and it's important to note that the department would be required to consult with stakeholders prior to adding or removing a species to that list. Furthermore, civil penalty, suspension, and revocation of license authority would be added. This additional enforcement authority would be there to protect consumers from abuses of law, and would also bring up the act to standards to other laws KDA administrates, with the ability to handle some of these enforcement administratively and not through the judicial system. There are many other changes to clarify language and make it easier to understand. Second, proposed amendments to the Plant, Pest, and Agricultural Commodities Certification Act would serve to modernize the existing licensing structure to live plant dealers. These updates would solve several issues. The changes to these structures are outlined in the attachment that we provided in our testimony. The current law requires that all live plant dealers are licensed except those under $10,000 of gross receipts and do not import-export plants. Exempt dealers, though, are otherwise required and subject to the same requirements of all other licensed live plant dealers and incur the same cost to the agency as licensed dealers and with inspections and processing the application. Furthermore, the term exempt creates confusion amongst dealers and consumers. The updates in House Bill 2563 replace exempt dealers with a reduced fee live plant dealer license and a specialty event live plant dealer license registration requiring no fee. The live plant dealer eligible for a reduced fee license if they do not export live plant dealer plants from the state of Kansas, have gross receipts under $5,000, and a single location. This helps live plant dealers that are small but are wishing to import small amounts of plants from other states, most likely neighboring states that you might see in the Kansas City metro area. As an example, folks who are wanting to buy and import plants from Missouri would be eligible if they are under $5,000. The special event live plant dealer fee registration are meant for nonprofits and similar groups having short-term fundraising sales. Additionally, under current law, all locations must be licensed, causing frustration with live plant dealers that have temporary locations for sales at farmers markets, festivals, and similar locations. House Bill 2563 defines a temporary location and would be exempt from licensing requirements as long as another location was licensed. Furthermore, many live plant dealers continue activities throughout the year and winter months and only renew when they begin sales or are visited by a KDA staff member. To encourage on-time renewal, the bill establishes a late fee for licensees that fail to renew on time, and those would vary depending on the time that they actually get renewed, the late fee. Finally, updates to the Plant Pest Act will update the fees regarding and addressing funding issues within the program. We conducted a fee analysis on the cost of verification inspections. Those are inspections we do of live plant dealers versus the licensing revenue. Theoretically, the licensing cost should pay for the cost of us conducting those inspections. So the fee adjustment, along with the new structure, will cover the current cost of verification inspections. Finally, the requested inspection per hour cost is being proposed to be amended to $45 from $30 per hour. This will cover the cost of the KDA average per inspector I guess, costs that we incur just for having our employees. Both of these together, the licensing fee adjustments and the per hour costs, will help reduce or eliminate the year-to-year deficits we have in the Plant Protection Fee Fund. Finally, changes in House Bill 2563 amend the Commercial Industrial Hemp Act. After consulting with the KBI, the bill has a new section that provides authority to the KDA laboratory to offer hemp testing for a fee as requested by governmental agencies or law enforcement, and establish a fee fund to receipt those fees. Finally, since the Commercial Industrial Hemp Program has been implemented under the 2018 Farm Bill, House Bill 2563 revokes a majority of the research program statutes because they are no longer needed, and establishes the new sections that the revisor spoke earlier. So in closing here, House Bill 2563 will update the Seed Act, the Plant Pest Act, and the Commercial Industrial Hemp Act to conform with modern practices and terminology to ensure KDA can adequately carry out our statutory duties assigned to the agency and provide the necessary funding for a sustainable budget in the future. I'm happy to stand for questions at the appropriate time.
All right, thank you very much, Jeff. Committee, any questions for Mr. Vogel? Senator Straub.
Thank you, Mr. Chairman, and thank you, Mr. Vogel. Actually, does this increase regulations from the department on the industrial hemp program? Or does it increase fees?
This particular bill does not change fees for the Commercial Industrial Hemp Program.
That it changes the structure of the program from?
So the program, after the Commercial Industrial Hemp Program was established, we converted or changed, after those regulations were adopted, we converted and changed to the commercial program authorized under the 2018 Farm Bill. Prior to that, we were operating a research program, which those are the statutes that are being requested to be revoked, because that was under the 2014 Farm Bill, and the authorization to do that under USDA is expiring, and so these statutes are no longer needed since we are operating the commercial program.
Okay, and how does this compare with other states?
Our program, the Commercial Industrial Hemp Program, is approved by USDA. I would have to get the specifics on the number of other states that have approved programs, but it's very similar and meets the requirement of the USDA commercial industrial hemp requirements.
Let me clarify. How do the fees compare with other neighboring states?
Thank you. If you wouldn't mind, I'll ask our Commercial Industrial Hemp Supervisor, Braden Hoke, to come up to provide some insight on that. They have done and looked into that to some extent.
Welcome to the committee, Braden.
Good morning, Chair, members of the committee. My name is Braden Hoke. I'm the Industrial Hemp Supervisor with the Kansas Department of Agriculture. So if I'm understanding correctly, the question from Senator Straub was pertaining to, licensing fees for states that have implemented hemp licensing. So we did a fee assessment of the 45 states that have plans pursuant to the 2018 Farm Bill as approved by the United States Department of Agriculture. And there's quite a bit of variation in licensing fees across those state programs, where the lowest licensing fee or participation fee is seen in Texas at $100, and the highest is Rhode Island at $2,500. So I guess as compared to Kansas, the Kansas fee is $1,200 for a license. And there's really, I guess, no set federal requirement establishing those licensing fees. It's ultimately dictated by the state program. And I guess in conclusion, there's such a wide variation in those licensing fees. But Kansas is right there on the upper end of the average for the fees across those states that do have licensing programs.
Go ahead.
Thank you, Mr. Chairman. If I could I get a printout of those fees and the research that you've done, please? Thank you.
Any other questions for Mr. Hope? Senator Ware.
Thank you so much, Mr. Chair. Several thoughts are bubbling in my mind. One, because we're talking about seed today, and so I start thinking about hemp seed. Where are we in the process of being able to allow our farmers to utilize the native hemp seed that we know grows well here? In fact, you almost can't kill the stuff. At one point, that was disallowed. Where are we in the process of being able to utilize that benefit?
Sure. So the requirements for individuals to utilize hemp in Kansas has to meet the statutory definition of authorized seed or clone plants. And I guess that the requirement is that it comes from a source that has been tested as industrial hemp. So it tests below that 0.3% THC limit. And the issue with going and collecting naturalized cannabis, there's no guarantee that the plants that it produces is going to, I guess, constitute as hemp. But from the changes in this bill, it would establish, I guess, from my understanding, the ability for individuals to research naturalized cannabis to, I guess, for inclusive varietal programs to, I guess, further develop lines that would be more suitable for Kansas, because the hemp that is generally, I guess, used for the more industrial uses is imported from other states or different countries, and it's potentially not adapt or suitable for production in the state.
Any other questions?
If I may. Now, one thing about the money that we collect for the fees for the hemp program, is the state gaining money, or is this just paying for the program?
I'll refer to Jeffrey Vogel to answer that question. Thank you so much, committee.
Vogel, welcome back.
Thank you, Mr. Chairman. So when we established the fees for the commercial industrial hemp license, we conducted a fee analysis. And after the research program, what ran for 2 years, we had a surplus in the industrial hemp fund. And so, in fact, we established the license fee for the commercial industrial hemp license to be actually a little bit under the cost of what we were expecting to utilize those extra funds we had available to us. And so the commercial industrial hemp fund where these license fees are deposited pays for the entire program. We do not receive any other funding source to run that part of our program. So to answer your question, yes, it's entirely funding the Braden and the work he does. But in fact, the analysis we conducted at the time was in fact a little bit below we were expecting our cost to be.
Where?
Thank you. Just one more question. Back to the seed idea and being able to use native seeds. Wouldn't a lab be able to test? I mean, isn't that what the labs are for, is to test the crop? Why are we needing to have the seeds? You see where I'm going here? If we're going to test it anyway, why not be able to use native seed?
Thank you, Mr. Chairman. I do want to help clarify the couple sections that are showing up in this bill. The sections in the Kansas Seed Act that refer to adding industrial hemp or plants in the species cannabis to the definition of agricultural seed is to extend those label protections to the consumers or the farmers that are buying industrial hemp seed, and to specifically clarify that that is an agricultural seed and that the label requirements, just like other crops that farmers grow, meet that. Then there's the new section referring to the industrial hemp 4-fee testing that the agricultural laboratory would be conduct, and that's referring to testing plant material. In fact, which is a little bit different than just testing the seed for label guarantees, germination, freedom from noxious weeds, et cetera. If that hopefully answers your question, but I can certainly defer to Braden to clarify too, if you you wouldn't mind, Mr. Chairman.
Any other questions, committee, for Senator Francisco?
Thank you, Mr. Chair. I'm just interested in terms of the live plant sales. Does this mean that if you have a garage sale, you can't put out your spider plants?
Thank you, Mr. Chairman. In those particular cases, when we're thinking about individual sales, in cases like that, we look back at the definition of live plant dealer, and we feel like that would not fall in to the definition of live plant dealer specifically because of the term in business, commercial type, I guess, consideration with those types of sales. So like example is if you were selling a single plant to your neighbor, we feel like that would not fall into the definition of live plant dealer and not required to be licensed.
Thank you for that. And then another question that comes from a constituent some years ago was a concern about milkweed, because there's particular insects that are helpful to milkweed, and they were concerned that sometimes the rules were asking those insects to be killed instead of sold with the plants. So I don't see anything in here that would prevent that, and just want reassurance.
Thank you, Mr. Chairman. To clarify, in particular cases where live plant dealers are growing or reselling plants for sale, we have in regulation, and it's authorized in statute, a pest freedom standard list of insects and diseases where there may be tolerances for those to be on live plants. The idea would be is if you were a consumer and going to a store and buying a plant, you do not want to buy a diseased plant that will eventually die or potentially spread that disease to your other plants in your garden. I'm somewhat familiar with this particular circumstance, I believe, and this particular pest, the aphids, control is dependent, or require of control is dependent a little bit on the circumstances and the level of infestation, because aphids are also vectors of diseases and they move diseases. So if there's disease presence and aphids are present, we're much more concerned about that particular species being present because of the fact that you could end up spreading a plant disease causing significant issues within that growing. And so depending on the circumstances, the department will use discretion on if control is necessary or not.
Senator McGinn.
Thank you, Mr. Chair. I have some concerns about on page 18, lines 32, I believe Senator Francisco touched on it, and then looking at the explainer on, in your testimony. The concern I have is that we have a lot of local growers that are just trying to make a living, and they sell, like they may plant their tomatoes and then they do some seeds and sell a few more to make some extra money, or somebody does herbs and all that kind of thing. I'm trying to understand why we had to drag them into this language, because it looks to me like by definition, our little small local growers are, if they exceed this, they're going to be drug into this.
Thank you, Mr. Chairman. And the development, I guess, of this structure, we worked with the Nursery and Landscape Association, but it was a lot of this led to this, I guess, this model, this proposal from our experiences with the exempt class that we currently have now, which caused confusion, specifically at farmers markets and the requirements and of some of those small dealers. Do they have to have a license? Do they have to be registered with us? What do they have to do to provide, or at least be compliant with the Pest Act? And so our a compromise or solution was to create this reduced fee licensed classification for some of those who do not export, who may import and have gross receipts under $5,000. Although in the act, it refers to a maximum license fee of $50. In our handout, and I'll clarify here, our plan is in regulation to adopt, if this bill passes, to adopt a license fee of $30 is our plan moving forward.
Just still trying to understand why they got drug in. I get, what is it, you got landscapers and contractors and, you know, these are the little 10-acre growers that grow either from their farm or drive 10 miles to their farmer's market on Saturday.
So
they're not exporting. They're not going across state line. They're buying good seed because they have to.
Thank you, Mr. Chairman, and I certainly understand that. I think as we look at this, is even under the current system, even individuals who are potentially growing from seed or overwintering plants and taking cuttings and planting those and selling those, there is some risk associated with them potentially of harboring plant pests and selling those plants to individuals, and that's, I guess, the basis behind one of the things I discussed earlier about incurs similar costs to the agency for inspections, because we would still conduct a random verification inspection on those individuals periodically to ensure that the plants being offered for sale in commerce met those standards that are established.
Do we do that currently, inspections of these local growers?
If they have registered with us as an exempt live plant dealer, it will be put on a verification list where over a period of time we hope to visit all of our licensees, but it's random up to the point that it may be on year 1 or year 2 or year 3, et cetera. But we just go in, and a lot of times what we focus on, Senator, is education and information, and if there was an issue, we try to let them understand what are the control options, what are the things you can do to ensure that you're not moving this particular plant pest if something was found. So that's
Registration and inspection, so now I think I understand what my constituents' concern is, so that's all I had. Thank you.
Senator Straub.
Thank you, Mr. Chairman. Just looking of the bill even further on page 3 and 4, all the language that is stricken, all of the different weed and seed, why was that stricken? And then also on the same page, on page 4, on line 40, could you elaborate on what seizure means and why that language was changed?
Thank you, Mr. Chairman. In regards to your first question about the removal of the lists, specifically with noxious weed seed, currently in the Kansas seed law, it includes noxious weeds designated in the state of Kansas, but they were listed there. And since in 2018, there was changes to the Kansas Noxious Weed Act, which established the list in rules and regulations. And so because of that, we're proposing to change that to a reference so that the Seed Act, so the noxious weed seed listed in the Seed Act is the same species listed in the Noxious Weed Act too. So there's not a confusion on what is or what is not, because currently in current law, there actually is a species in this list that is not declared noxious in Kansas currently. The other thing, looking at that, is we, working with industry, we moved the restricted weed seed list, looking at that, striking through those species, and we created subsection 1 and 2 to essentially create the requirements for species under that list, and then to designate them by rule and regulation upon consultation with stakeholders. And our plan, at least initially here, is to adopt what currently is in statute and rule and regulation going forward. This will provide clarity within the industry so we can, have that in table form. Regards to your question regarding seizure, I believe that definition is in regards to the judicial process later on in the actual Seed Act, where the judiciary could, I guess, issue an order for seizure. It's not something that the Department of Agriculture would do administratively.
Thank you, Mr. Chairman. So I just want to make sure I have this straight. So by striking that language, it's referring to back to rules and regulations, and it says adopted by the Secretary in consultation with landowner organizations, seed industry organizations, and programs within the College of Agriculture of Kansas State University. So that list of restricted weed seeds would not be definite. It could change year to year, month to month.
Thank you, Mr. Chairman. And our anticipation is no, it would not change, but the possibility of updating the list depending on the particular circumstances at the time would be there. But this list has not changed in several decades, but working with stakeholders, we came to the conclusion of suggestion to modify how that list was established and removing it from statute and putting it into rule and regulation.
Senator Peck, do you have a question?
Chairman, thank you, Mr. Chairman. Yes, it's a short question. I don't know about the answer. I noticed as the legislation was proposed in Section 7B, which is on page 13, that the fine or the civil penalty was set at not less than $100, not more than $1,000, but the House changed it to $3,000, and they struck language after that about each day could be a new violation. Can you just briefly tell the committee what was the thinking of the House or the reasoning from moving it from 1,000 to 3,000? Because I kind of like the other part, but the triple of the assessment or the fine seems a little excessive to me.
Thank you, Mr. Chairman. And that was and maybe the next proponents can discuss a little bit more, but that was a compromise. Some of the stakeholders we worked with were concerned about the continuing violation language. And if, for example, if there was a particular violation and it continued for 30 days, there could be and it was deemed as a continuing violation, there could be a substantial fine associated with that. And with that, we removed that language and then just raised the cap of the entire, the maximum fine to $3,000. That was, I think, the source of the compromise that we came to because of the concern with the continuing violation language that was underneath that.
Thank you, Mr. Chairman.
Next conferee is proponent is Randy Stuckey from Kansas Agribusiness Retailer Association. Welcome to the committee.
Good morning, Mr. Chairman, members of the committee. Randy Stuckey this morning on behalf of the Kansas Agribusiness Retailers Association. We do stand in support of this bill, House Bill 2563 this morning. Principally, one of the questions that was just asked, it was an issue that we brought to the agency on the civil penalty portion that we did ask for removal of that continuing violation language, and then in agreement with the agency, we agreed to increasing the maximum civil penalty. In addition to that, we've also have an offline agreement with the agency that they will work with us on assembling some form of a penalty matrix so that we have an idea of what violations will equate to what kind of a civil penalty. So not everyone's going to get the maximum civil penalty of $3,000. There are different types of violations set forth within the Act, and the civil penalties that would be apportioned to those violations would be something that we could meet with the agency on and find some agreement on that. So with that, we did agree to the increased maximum civil penalty from $1,000 to $3,000. It's a broad bill, to be sure, and there are a lot of moving parts. Clearly, we are interested in the Kansas seed law portion. To that end, we appreciate the Department of Agriculture working with us. I think it was back in August of last year we had initial conversations about, what these changes were going to be. Even in the Kansas seed law portion, we have comprehensive changes of the Act itself. So it took a lot of back and forth with the agency, and requested language, requested changes, and our response to that, I think there were 4 or 5 back and forths on that to get us to where we are on this language. At that point, we do stand in support of the bill, but certainly stand for any questions at the appropriate time.
Any questions? Where?
Thank you, Mr. Chair. And honestly, it might not be a question for you, it might be a question for the department. I think it was a really insightful and important question that Senator Reichman asked early on, and that is, why are we looking at fingerprinting folks?
Thank you, Mr. Chairman. I'll defer to the agency.
Welcome to the committee, Senator Titus.
Thank you, Mr. Chairman, members of the committee. Kenny Titus, Chief Counsel, Kansas Department of Agriculture. That provision, so as the research program originally existed, excuse me, it required that everybody that was involved with hemp have a background check before they could participate, including state employees. In the new commercial program that's been active for the last couple of years, we significantly reduced that requirement. So when we were cleaning out the research program, we realized there was no other authorization for us to get a background check of Department of Agriculture employees. So what we did was we amended that little piece of the Research Act that allowed us to background check our own employees if we think it was necessary, just to ensure the security of the hemp program. So that change is only applicable to KDA employees that are overseeing the hemp program, or it would be going forward.
Committee, just, we're kind of running short of time here. I did want to spend some time on the lifetime hunting and fishing bill, which we talked about yesterday. So I'm going to suspend the hearing, the rest of this hearing for this 2563, and we'll take it up down the road here. But for the time being, we will move to our attention to House Bill 2456, and where we left that yesterday, or the last, is that I brought an amendment that we talked about at the end. The only one who didn't get the language was the revisor. That Secretary Lovelace sent to everybody, but he left out the revisor. And we have those passed out. And what it amounts to, we were talking about the January 1st effective date. And between Secretary Lovelace and Mr. Representative Corbett, they've agreed to this amendment language. And would you like to come and explain that, Representative Corbett, and give your thoughts on that?
We agreed to this just for the fact we need to get it out. When you're in private business, you wouldn't think it would take from March to January, but things move slow. So we need to get this out, and they've agreed that if they can start selling these in July, they'd give the recipient a gift certificate to be redeemed in January with the official card. And I believe they've also agreed that if, due to the delay in implementation, that if a child is somewhere between 5 and 6 on the first year, they've offered to be a little bit lenient, because the goal is to get these licenses sold. So I'm in agreement, the Secretary's in agreement, and I'll take any questions.
You want to touch on the fact about the certification that they talked about a little bit?
On the hunter safety, we're in agreement on that, knowing that the 5-year-old won't be able to take the test till they get older. But it's a good thing for all people who are going to be hunting to have hunter safety. I wish it was pushed more in the schools.
Anybody have any questions for Representative Corbett? Seeing none, thank you very much. Committee should have a copy of that, the amendment, on your desk that we were sent out by email, and then Judy brought one for everybody today, so it's that Kansas Wildlife and Parks. Everybody find it? That's the language in the middle. It says language for the amendment. That's what we're going to be asking to have changed. Everybody got that? Revisor, you want to make a, have you just seen it? We're calling the revisor to explain the amendment.
So in just having looked at this, my understanding is it would add a new subsection D that would allow the Secretary of Wildlife and Parks to adopt rules and regulations to implement and carry out this section regarding these licenses. The statute, or the bill, excuse me, instead of taking effect upon publication in the statute book, would take effect upon publication in the register, which I think ties to the rules and regulations, so it would allow the secretary to go ahead and start working on those rules and regulations as soon as possible. But the actual issuing of the licenses would be delayed until January 1st, 2023. I think I understand.
Thank you very much. You did a really good job, Tamara, on short notice there. Committee, any questions on the amendment? Senator Francisco.
Thank you, Mr. Chair. So I understood that some of the intent was to be able to sell these gift cards or do something ahead of the time, but the wording still would be that on January 1st, 2023, the secretary is authorized to issue the license to any child who's 5 years of age or younger. So I think Representative Corbett looks like he wants to answer this.
As we agreed, they're too young to hunt this fall anyway. So if my main goal was these would make great Christmas gifts. They're also great things if you're doing a fundraiser or a conservation group or just any fundraiser. You could pre-buy these gift certificates and try to raise some money for your organization. And I'm hoping that they'll follow through on that and get those developed.
Question, Senator Francisco?
So if it's a gift certificate, how do you tie that certificate to an age of the individual who's getting the license?
Well, the gift certificate would be as a gift certificate. If someone auctions it off, they'd still have to be in compliance with the rules and regs when they actually got the license bought and issued. It'd be just like you're saying, Senator, if you had a fundraiser, you could buy, normally you could just buy, you would say, we are giving away a youth child's lifetime hunting license. And then the recipient would have to qualify if they want it.
I'm trying to understand how we, in this set of amendments, are allowing for a child who would turn 6 before January 1st, 2023 to get a license.
Just a minute. Would you like to say anything on this?
Mr. Adams, come on. You got to go ahead and.
Thank you, Mr. Chairman. That is one of the problems that the regulatory process through the commission that we would have to sort out if that's the will of the committee for us to do that. There are also some other issues that the regulatory process is important for us to sort out, such as how do you establish residence for an infant? How do you have an identifier for an infant? You as an adult, if you go buy a license, at a typical age, you might bring in your driver's license. Proves who you are, proves where you reside. Obviously, an infant isn't going to have a driver's license, isn't going to have a bill that they have paid, so forth. So we need to work through that, understanding that there is potentially sensitive information related to that individual, and how are we going to make sure we gather the information that needs to be gathered, understanding we're dealing with very young individuals.
Mr. Chair, I'm in favor of this bill, and I'm in favor of it moving forward. I hope that if there is anything else, that the conference committee might be able to work out that specific language since there's a change.
Senator McGinn?
So I would entertain a 5-year sunset just so it could get looked at sooner, make sure everything is doing what it's supposed to do. It's a 10-year sunset.
Or it's already there?
5 is?
The whole bill's got a sunset on it already.
Right, 10.
Yeah.
Yeah, I was suggesting to move it to 5 so we could take a look at it again to make sure the bill's doing exactly what we want it to do. So I'm having that discussion with my conferees, or my senators.
We could work that out.
And then,
too.
well, I thought if we put it in, then you could work it out in conference, and you could have that conversation.
It's up to the committee. You want to make a motion to,
I'll just fly it. A motion to have a 5-year sunset after it's enacted, because it's going to take a while to do that. And then you can review.
is there a second? Making that a form of motion.
Yeah.
Is there a second? Seconded by Senator Ware. Any other discussion? Senator Peck?
Thank you, Mr. Chairman. I believe I fully understand, but we're on line 19, changing from 2032 to 2027. Is that correct? That would be a 5-year
That's the 5 years after the delayed enactment. So it'd be 20, it'd be further than that, wouldn't it? 28, because they have to delay starting.
Okay, so we're looking at July 1, 2028, rather than July 1, 2032.
That's right.
All right, thank you, Mr. Chairman.
Tamara, Supervisor?
I just need a little bit of clarification. If the sunset is changed to 2028, does the committee then need to change the on and after July 1, 2027 with the increase in the maximum fee?
Senator Francisco?
I don't think we do. And I was trying to look at those 2 dates because I was hoping the date that expired was after the increase, but that would be the time that we could have the discussion again about were the fees enough and what had the federal government done.
Committee, did we make that a motion? Second it. Okay, the motion is to make it 10 years, 5 years, 5 years to sunset. Any other discussion? Hearing none, all in favor say aye.
Aye.
Opposed, no. The noes have it. It'll stay at 5 years. Okay. Stay at 10. Okay. Committee, any other comments? Because I want to move my amendment on the language that was submitted. Senator Fagg.
I was going to second that.
Oh, okay. Moving second, we adopt the language for that from the Department of Wildlife and Parks and Representative Corbett. Any other questions? Seeing none, all in favor say aye. Aye. Opposed, no. That amendment is adopted. Tamara, what did we do wrong?
Nothing. I would just like a little bit of leeway to clarify a couple of technical things that need to be updated in this language.
Yeah, absolutely. So, okay, committee. Any other discussions? Senator Peck.
Thank you, Mr. Chairman. Being someone who's fully trusting of government bureaucrats to always follow through like we intend for them to do, to make certain that this is carried out in the manner in which the proponent desires and the committee probably would desire. This is as simple as just a conceptual amendment, but change the age of 5 to 7. That way we don't have the issue of so much of the certificates. And I realize no matter what age we pick, we're going to cut some people off early. But the original intent was 5. This makes certain that we comply and even give a little bit of a cushion. So I would make a motion to change the age of the child who is 7 years of age or younger, or from 5 to 7.
All right, committee made that motion. For a second. Any discussion? Senator Francisco.
Thank you. I would be concerned about supporting this without hearing from the department about how that changes the funding.
Any other thoughts? All in favor of the amendment, signify by saying aye. Aye. Opposed, no? No. Motion fails. Any other questions, comments? Senator Fagg.
Thank you, Mr. Chairman. I'd move that we move this out favorably as amended.
Been Moved and seconded, we move the bill out favorably. Any discussion? Seeing none, all in favor say aye. Aye. Opposed, no. Same sign. Motion carried. Committee, we are adjourned.